is OPE review of contracts. It's on the statute of frauds. UCC, agreement between merchants. UCC is lenient in writing requirements. You have no written contract, but reasonable time after oral agreement. A sends B a written confirmation. That's enforceable. Statute of frauds in the contract for sale of goods must be evidenced by a writing against whom contract is sought to be enforced. Exception is where the party accepts goods. Accord and satisfaction is a good faith tender that is accepted and the duty is discharged. An example is a check is tendered with, quote, payment in full. It's acceptance of the check when dispute as to amount due constitutes an accord and satisfaction. A novation is a three-party agreement where one party is substituted for another and the other party being released. Right, some issues with consideration. There's an exception to consideration where consideration is generally required. So where statute of limitations is in play, a promise to pay a debt after the statute of limitations has run is enforceable without consideration. This is a long-established exception to the consideration requirement. Consideration in the context of third-party contracts, an assignment of payment rights from B to A to bank works as consideration. This is an addition of an obligor from whom payment could be received. Looking at consideration in the aforementioned accord and satisfaction agreements, consideration is present if it is made in good faith. Here, each party surrenders respective claims as to how much is owed. In divisible contracts, there's a construction contract. The facts were where there's one contract for the building of three distinct houses on separate parcels. Here they're all in one claim. You need not bring separate claims for each component as regards to efficiency. In that context, the builder could recover for the cost of the first house, but would be liable to the landowner for breach for failure to build others. Conditions, the doctrine of prevention in regard to conditions, where performance is subject to express conditions, the party must refrain from conduct that prevents and or hinders occurrence of the condition. Looking at advertisements, this is inviting performance. An example is the bank poster where you stand in line longer than 5 minutes, you get $25. It's a unilateral contract, meaning offer invites acceptance by performance. Beginning performance creates an option contract. This precludes the offer from being revoked, meaning standing in line was not acceptance. Reaching the 5-minute maximum was acceptance. And the damages, types of damages, you have expectation recovery. This is the make them whole. This is the benefit of the bargain, the position they would have been in but for the breach. This is the loss in value plus other loss minus cost avoided minus loss avoided. You have damages, restitution recovery. This is the benefit conferred on the owner. Damages, reliance recovery. This is unreimbursed expenses such as labor or materials. Damage, you have consequential damages. This must be reasonably foreseeable to the breaching party. In regards to a lost volume seller, quote, lost volume seller, end quote, is a seller not operating at full capacity. Here they may recover for lost profits and direct damages. Manufacturer and an action for the price of goods where the buyer accepts the goods or goods are lost or damaged within a commercially reasonable time after the risk of loss has passed to the buyer, or where the buyer has returned and or rejected goods and the seller is unable to resell them after reasonable efforts. They may have an action for the price of the goods in those contexts. In regards to wrongfully rejected goods, the seller may recover the difference between the contract price and the resale price. Specifically looking at where a bank cancels a loan prior to closing, the borrower recovery against the bank is limited to the difference in cost over time between a loan at 10%, what they eventually obtained, and 8%, what they could have had but for the bank's breach. Okay, contract for sale of goods is where a selection for the goods is not made at the time of contract. This goes to the candy bar question. This is a failure to specify. A selection is not made where the selection was not then eventually made on time. This is a breach if it materially impacts the seller's performance. Example, supply of candy bars or other contracts to fill. So the seller has other obligations to fill. Failure to make a selection, breach if it materially impacts their ability to fill those other orders. The failure to select where it has material impact on the seller's performance, seller may make a reasonable selection and ship them. Contract for sale of goods and tender and payment. The facts of this question here indicated a concurrent conditions of exchange, the requirement of simultaneous tender. This is a question or the fact pattern where they had the sale of a car on a specific date. The seller sold the car before that date and buyer arrived but did not have sufficient money to complete the purchase. The seller did not breach because the buyer was not prepared to tender. So it's a constructive or it's a concurrent conditions of exchange. Repudiation. Repudiation may be retracted. Retraction is ineffective if the retraction occurs after the injured party has materially changed position in reliance on the repudiation. Anticipatory repudiation is an unequivocal manifestation of an intent not to perform. Expressions of doubt or requests for modification, example, extensions of time to perform because the party is busy, are insufficient for anticipatory repudiation. Expressions of doubt may, however, give rise to right to demand adequate assurances. Look at contract interpretation, the parole evidence rule. Condition exception to the parole evidence rule is permits admission of extrinsic evidence to establish an oral condition to performance. Absence of prior oral condition in a later written contract indicates the written contract is not completely integrated. Contract interpretation and insurance policies, they're generally, as a general rule, they're interpreted against the drafter. Contract interpretation and the merger clause. Presence of a merger clause does not conclusively establish that agreement is completely integrated. Contract interpretation and complete integration. Complete integration does not necessarily bar admission of extrinsic evidence, and we talked about that above with the condition exception. Third party contracts, third-party beneficiaries. Looking at an intended beneficiary of a contract, parties can generally change a contract unless and or until a beneficiary relies on the contract. Then the parties cannot change and or alter the contract after the beneficiary relies, and this is where the two owners of a business agreed to fund a retirement for somebody at $100,000 each. The employee relied on getting that $100,000 from each party, went and purchased something, and then one of the other owners wanted to modify it to $50K. Well, then they couldn't because the employee had relied. Look at installment contracts. Under the UCC, an installment contract, you may reject non-conforming installment if installment substantially impairs value of installment and it cannot be cured. Prior acceptance of non-conforming tender in installment contracts does not constitute of a waiver of right to reject if other ground for rejection is satisfied. The perfect tender rule does not apply to installment contracts. Perfect tender under the UCC applies, but not to installment contracts. Substantial impairment standard applies to the right to reject. So installment contracts don't apply perfect tender and apply substantial impairment. Contract formation under the UCC, additional terms are part of the contract unless the term materially alters the party's contract. That's in regards to the exchange of forms. Warranties. The warranty of merchantability is an applied warranty and need not be stated or bartered for as a condition. And that is the question where they somebody made an offer, and then the reply to the offer is, I will accept that as long as you provide me a warranty for merchantability. And then the other party went ahead and sold it anyway without taking their acceptance. As valid acceptance at what it reads as a modification, but it is, or a counteroffer. It reads as a counteroffer, but it's not a counteroffer because the warranty for merchantability is implied and need not be stated and or bartered for. That completes OPE review of contracts.